Welcome to the Grow Your Law Firm podcast, brought to you by Pilma. This podcast helps lead lawyers to more growth, profit, and freedom. Here is your legal marketing expert and host, Ken Hardison.
Well, hello, everyone. This is Ken Hardison, and welcome to another episode of Grow Your Law Firm. And today we have the honor and the pleasure of having John Cooper with Cooper Hurley Attorneys up in the Norfolk, Virginia Beach area. Thank you, John, for being with us today.
My pleasure. My pleasure.
Yeah. So I've always said there's riches and niches, and, you need to be thinking about more than this MVA cases. So you need to be thinking about dog bite cases, motorcycle cases, places where so much traffic, so many people trying to get the same type of cases. And you really want to try to get these lucrative cases. And John is an expert on railroad track cases and railroad cars and Amtrak cases. So we're going to talk about that today and the challenges with that, but also the rewards of that. So thank you, John, for being here.
Thank you so much, Ken. Really appreciate it. And yeah, railroad is one of those great niches. I am proud that I got an opportunity early in my career to work on cases involving railroad workers and Amtrak cases for passengers as well as workers. And it is a fascinating and often lucrative area of practice.
I remember way back, I had a case where the signal's supposed to go down and it didn't. And my guy actually got hit by a train. It was a pretty interesting case. And I really, to be honest with you, I had to get somebody else in it because I didn't know what I was doing. Because there's a lot of different laws with that, right?
Exactly. It really is a whole specialty area of law. And so one of the things I hope to talk to you all about today was just to explain a little bit more about railroad worker injuries, why they're different, why they're valuable cases, and what you should do if you see one of these in your practice. Can I go ahead and launch into a bit of that?
Yeah, go right ahead.
Thanks. So we just wrote a paper and did a presentation about railroad injuries, and we basically had it in three categories. One was the worker injuries, one is the passenger injuries, and one is the crossing accident cases. Now, what you just mentioned is a crossing accident cases, and those can be incredibly tragic. Folks losing their lives, being hit by the train. One thing that's different about the railroad industry is each locomotive weighs over 500,000 pounds, and each rail car unloaded weighs about 200,000 pounds. So you're talking about a lot of steel on steel wheels, and people regularly get very seriously hurt. When there's injuries, they're often really big injuries. So what ended up happening is about the time that workers' comp statutes were first coming into effect, and this is the turn of the 1900s, railroad was the most dangerous industry in America. Men were regularly losing their lives, having their legs or other limbs cut off, just a bunch of gruesome stuff. And it was just the cost of doing business. The Transcontinental Railroad was making great strides to basically change the American landscape. And luckily, at that time, some forward-thinking people said, we need to protect these railroad workers and their families. And they put in a special statute, federal law called FELA, the Federal Employers Liability Act, which we usually call FELA. And that governs when you get hurt on the job on a major railroad like Norfolk Southern, CSX, Burlington Northern, United Pacific. And what ends up happening is these workers do not get workers' comp. And so if they call a regular local lawyer, somebody may get very confused about what exact box this fits into. So for those of us who do a lot of the FELA work, we mainly want to let other lawyers know that we're happy to talk to you and think about how together we can make sure that the railroad worker is getting protected. The cool thing about FELA is it's actually more favorable to the worker than workers' comp. Ken, how often if you're telling somebody, hey, it's a workers' comp case in Carolina, wherever, and that's it, there is nothing else, it's a tragedy for these families, right? I'm sure you've seen that throughout your career. And so in workers' comp, you only get your medical bills and some part of your wages, maybe something for a permanent injury, but it's intended by definition to not be a full remedy. You're not really getting fully compensated. Right. Whereas FELA, number one difference is you can sue your employer. If you or I get hurt on the job, we can't sue our law firms, even if the law firm was negligent in causing us to get hurt, because we're covered by workers' comp. That is not true for railroad workers. And when I say railroad workers, Ken, we're talking about the major railroads. We're talking about those big companies that I mentioned. The freight railroads of America handle an incredible amount of volume of traffic every year. And that's where most of the workers are, is working for big companies like CSX, Norfolk Southern, Amtrak, and their workers also come under the same federal law. Tell me what you know about FELA. I'm interested because, I think the average practitioner doesn't know all that much.
I don't know a thing about it. I don't know a thing.
And what's funny is, I'm sure in your town, and as in my town in Norfolk, Virginia, you see the trains all day. You hear them, sometimes feel the slack action or things, when they're banging their rail cars together. And that's happening in every town in America, essentially. But most of us don't know much about it. Railroad workers, they're kind of a different breed. They are incredibly well-paid blue-collar workers. So these are guys and gals with a high school diploma who can be earning $100,000 a year moving the freight. Now, they work incredibly long hours, but it is a really lucrative job, in part because it's unionized. And that's something that's totally different. Here in our state, there's hardly any unions at all. But the federal railroad workforce is a unionized workforce. So I represent.
I got a question.
Yes,
so
sir.
Is this the same thing as just federal workers' comp, or is this is this on top of federal? See, that's what I'm thinking, because when I was doing workers' comp, we did a lot of them in North Carolina workers' comp cases, but we would not handle federal workers' comp cases just because it just wasn't lucrative. I mean, it just, there's very few lawyers that would do it in the country, and we would refer them out to the few that would do it. And I think they limited your fees and did a lot of different things that made it hard.
And that's a great question, Ken, because you would think, oh, it's federal workers' comp, but it actually isn't that either, because these aren't federal employees, right?
Right.
And so there's lots of confluences where different laws come together. One of them, for instance, here in the maritime area of Virginia, will have maritime workers who sometimes come under FELA and sometimes come under longshoremen's workers' comp jurisdiction, which again isn't FELA and is less valuable than FELA. So the main lesson, I think, to our viewers and listeners is, if you hear that it's a railroad worker who got hurt on the job, assume that it is FELA until you know otherwise, because it's a lot better remedy. Now, railroad workers do have Social Security through a thing called the United States Railroad Retirement Board, the RRB, United States Railroad Retirement Board. And so there are both sickness, short-term benefits, and long-term retirement benefits through that system. But that's actually over and above your right to sue your employer. Listen to these rules. They're crazy. If you're from a state like Virginia, it's amazing to work under these rules. Pure comparative fault, not even 51% comparative fault where you have to be less at fault than the other person. If you, as a railroad worker, are even 90% at fault and the railroad is 10% at fault, they're responsible for their 10%. So pure contributory regime. Another thing is, we get to pick in FELA whether you sue in the federal court or the state court. There's almost no other remedy in the nation where you can say, no, I don't want to go to the Tennessee state court. I want to go to Tennessee federal court. Or in Florida, I want the federal court. I want the state court, not the federal court. Right. And the railroads cannot remove that in the FELA context. Now, Amtrak is a slightly different animal. We're going to talk a little bit more about Amtrak later. Amtrak, being essentially the federal government, 51% owned by the United States, is a slightly different animal. But I can sue Norfolk Southern here in my local courthouse, state courthouse, or the federal courthouse, plaintiff's election, and they cannot remove us or remand us. So that's an amazing thing, too.
Yeah, it is.
The real value in the cases is these folks' jobs. So if you're a railroad worker and you're being expected to lift 50 to 100 pounds every day, 50 to 100 pounds, medium to heavy work, you're going to end up in a situation where if you've got a bad back, something that you and I might be able to work through, if you have to lift 50 to 100 pounds, you can't go back to work with a back injury until it's healed up. Any work restrictions are going to knock you out of that job. So these guys have huge lost wage claims. And if it's a surgery and they're out for a year, even if they go back to the railroad work, you could easily have $100,000 in economic losses for their job. So that's really where the money is in these things. Interestingly, the medical bills are not the main driver because the medical bills are paid for by the railroads through a union contract. So the railroad has paid the bills. If you claimed them in court, they'd get a credit or an offset. So it's usually all about the wages is where it is. But unlike workers' comp, you get pain and suffering, you get deformity, you get permanent injury, and you can claim future medicals. So there's a lot of interesting damages information. But what really separates out the FELA lawyer from the non-FELA lawyer is knowing how to prove the liability. Listen to this phrase from one of the Supreme Court cases in the field. The negligence of the railroad only has to be negligence in the slightest degree. What? The slightest degree of negligence. So if the railroad caused it, even sort of remotely, they're still responsible for the injury. So that's totally different than regular state torts where you might have proximate causation requirements. There's no proximate cause. The statute, FELA statute, says causation in whole or in part. Did the railroad's slight negligence cause the injury in whole or in part? And if they caused it even in part, the railroad's got to pay for the whole injury. So these rules are completely different and much more favorable to the injured person than almost any other kind of law in America. So I think the message mainly to other lawyers is if you hear a railroad work injury, stop, hold the presses, find somebody, and obviously we're happy to talk to anybody about anything with no obligation and try to point you in the right direction because it's a very different set of rules.
Yeah, absolutely. If you can get pain and suffering in a workers' comp case, my God.
Yep, you sure don't, do you? Sure don't. And so in FELA you do, and then the defendant is a railroad company like Norfolk Southern, who earns billions of dollars a year and is has more money than whatever. They have so much money that they don't even have insurance companies until they get to reinsurance at the $30 million and $50 million level. They have an in-house claims department. So instead of dealing with an insurance company, when we're negotiating, we're dealing with the in-house army of claims agents that the railroads have. And of course, they know this stuff very well. And so if you get on the phone with them and you don't really know what you're talking about, they can sense that pretty quickly and may try to take advantage. Their job, just like insurance companies, is to pay the worker as little as they can get away with in exchange for that release. So one of the things that happens in these cases is the guy knows right away that he's hurt. These are big injuries. These aren't, typically, minor injuries. These are some major things. Somebody's lost a finger or somebody, has been thrown off of a railroad car, some pretty bad accidents. And so they are required by their work to fill out an accident report that very night. Doesn't matter if it's 3 a.m. and how hurt you are, they will often refuse to let you get medical care until you fill out their incident reports. So one of the things we do is go around the country and show these incident reports, which are available online, by the way, so that the worker sees the Norfolk Southern or CSX incident report before he's faced with it in the middle of the night while he's in pain and trying to get to the doctor or the hospital. And so there's lots of little tricks in there where they'll sort of make it sound like they're not at fault and try to get you to say something that makes it sound like your fault. So railroad workers are very smart. They know about their own industry. They know what the rules are, and they're trying to be safe for themselves. But it's a very adversarial relationship between management and labor out on these railroad yards and on the road, because the railroad is trying to blame the worker almost immediately. And so the sooner we can get involved, the better, so we can try to make sure some of these early things go the right way. And in that way, it's similar to other like industrial accidents or premises liability accidents. One cool thing we get to do is we get to put on our safety equipment and go march around the railroad yard or, at various scenes of accidents to inspect the cars, inspect the track. And that's interesting because the more times you go out and do that, the more you become familiar with, boots on the ground and what it looks like to do that job.
And I'm sure you've got some expert witnesses that you use on a regular basis, I would think.
Absolutely. You have to have them ready to go. So when you have to jump out there and inspect a scene before they change it, you're ready to go. But basically you have three parts of a major railroad, major freight railroad. You've got the transportation department, which is most of what we think about: engineers and conductors, the train crews. That's transportation. And then the second thing you would have is the mechanical department. That's the carmen and the machinists who fix the railroad cars, inspect the railroad cars and locomotives. And then the third department, and this is the hardest work of all, is the laborers who are in what's usually called maintenance of way, which is basically setting up the track. And that requires a lot of huge, physical labor. A lot of heavy equipment has to be moved around, a lot of possibilities for getting hurt. And these guys are typically out on the road. They're not at home where they're from. They're out in some other state, way away from their families, living in a hotel. And that's a terrible position to be in if you get hurt on the job.
Do you have to be from the state? So it's sort of like federal Social Security. You can represent somebody anywhere in the 50 states as long as you're,
Yes, sir.
got
It's federal law. So basically, whether it happens in Florida or in California or New York, it's all the same federal statutory law and common law. And then we keep licensure in a lot of different states. But if we're in a state where we're not licensed and we have to go into suit, we'll typically get pro hoc vicit in, get local counsel who can help us. So the only thing that really changes is maybe the procedure. Florida procedure might apply or the federal procedure might apply, but it does allow us to be nationwide essentially and represent people all over the country.
I think it would be important. I'm sure you got a big section. You just said you did some papers, and I think people the listeners need to catch on to this. You wrote some papers, and I'm sure they're on your website, and I'm sure you did some videos. I'm sure you got a lot of content because I know your marketing director, Cassidy, who is the one that runs our roundtables, our marketing roundtables at PILMA. And I know you got it because I know her. I know you got it on there. So you got to let people know you're doing it,
Yeah, exactly. And it really is a nationwide practice, which is interesting, in today's world, particularly with the ability to communicate by Zoom and other things. It's a little easier to represent somebody in rural West Virginia or, some state where you aren't physically present. Usually if we're doing a deposition, we're in full litigation and we're doing deposition of the plaintiff. Obviously, we're going to be down there with our client. But a lot of the initial stuff can be done, and a lot of the depositions can be done remotely. And then we have investigators who are in-house investigators who go out to look at scenes and interview folks for us. But Cassidy has really thrown a broad net out there because every state's got railroad activity. Some have a lot more than others. And then on the East Coast, CSX is headquartered out of Florida. So there's a lot of activity down there against CSX. Norfolk Southern moved a couple of years ago from my hometown in Norfolk, Virginia, down to Atlanta for their headquarters. But their operations are in, dozens and dozens of states. And so it doesn't really matter where the accident happened, although that can control some of the venue options, right? So it's always, you can almost always go to the place where the accident happened. But we also are very creative in being able to find other places where the railroad's doing business. And if we can come up with enough connection, depending upon what the venue rules are, we can often do some unusual things like, and this is getting a little bit into the Amtrak situation. And Amtrak venue is even more complicated, but you could have a person from Virginia Beach who gets hurt on an Amtrak passenger train out in Washington State, and then we handle the case either here in Virginia or in DC instead of on the West Coast, if that seems to be in the client's best interests.
Right. So let's change gears. So tell me about these. So we've talked about the FELA. How about these railroad crossing cases? Or you don't want to go to Amtrak next and then go to the railroad crossings?
Yeah. So Amtrak is kind of a quick, discrete topic. Let's talk about that for just a second. One of the things that can happen, obviously, with Amtrak is these huge disasters. The one in Washington State was one that I was working on, but they've happened in Philadelphia, obviously in Ohio, all over the country, in North Carolina as well, of course. And so when those happen, now you've got the NTSB out there, and you're going to have a pretty fulsome investigation of what happened. If it's a individual passenger who gets hurt, and that could be slipping on water, that's very common. It can be an Amtrak passenger getting on or off the train, which can often be challenging. or it can be even just being jostled during the ride if they hit some very rough track and they get jostled a bunch. And so in those cases, it's us against Amtrak. We know some of the buttons to push and some of the standard things that happen on Amtrak. So early on, we'll send a preservation letter, say, let us get access to this train car if it hasn't already been changed, or at least let us see it, which is important. You'll want to keep your ticket because we'll have proof that you were on that train at that time. Obviously, like any other premises liability case, the passenger wants to tell the train crew and make them fill out a report there and get their information so there's no question that it happened. And ultimately, these can be significant cases because a lot of times getting on or off the train, you can break a leg or something, very serious doing that. And the Amtrak folks owe you a higher duty of care than most other situations because they're common carriers, right? They're like a bus or another common carrier. And so they owe a high duty of care to their passengers. That makes the liability case a little bit easier. One of the things that's a sort of a newish development in Amtrak Passenger is they've added to the back of the ticket a few years ago a clause that calls for a mandatory forced arbitration. Now, there's lots of other law contexts where companies try to do that, and there are some potential challenges to it, but in very recent times, in the past year or so, we're now seeing where Amtrak will attempt to enforce that arbitration agreement. So then you have to consider, do we want to fight that, or are we willing to do arbitration? And then that creates a whole new separate different process. That's something that's a little bit problematic in the field these days. In terms of Amtrak passenger cases, the main thing is Amtrak can be very, very slow to respond. Dealing with their claims department can be challenging. And so kind of knowing who the players are, we know who to put on notice, we know who to call, we know how to ask for the preservation of evidence. And so those are things that give us an advantage. And that practice is also nationwide, of course. The one other thing I'll say about passenger before we move on is all these new Bright Line trains you may have read about. It was just in the paper about California starting a new West Coast version of this from LA to Las Vegas. And that's a privately run passenger train, which has a lot of appeal. They'll have faster service, hopefully, a little bit nicer service. But at the end of the day, the same risks are still there. It'll just be a private entity, Bright Line, that you'd be suing if you get hurt as a passenger on their system. Ken, everybody wants to talk about crossing accidents. And the reason is that's the one that we're most likely to see in our hometown, out, in the country near us. And it's a terrible, terrible problem. You're talking about huge numbers, thousands of people being killed each year in these, many more being injured. And so what ends up happening is that the train is running down the track and it cannot really swerve or do anything. And even stopping, if they threw it into emergency, they would probably overturn the train, derail it, and risk even more injury to more people, including the car or truck that's there at the crossing. So for that reason, the railroads are very good at blaming the victim in these crossing accident cases. Yeah. And so the cleanest of crossing accident cases for the folks out there, looking at and evaluating a case is where you have a passenger. If you've got a passenger who's a little kid, or you've got a passenger even in a 18-wheeler, some other situation where your client is not the driver, and therefore there's not a contributory or comparative fault problem, those are much easier cases to win because, truth be told, although the railroad is almost always doing something wrong, the driver may not have been sufficiently careful, at least in the eyes of the jury or the judge. Right. And in states like Virginia, North Carolina, Maryland, District of Columbia, and Alabama, the Big Five, who keep pure old-fashioned English contributory negligence, 1% at fault, you get nothing. That's technically what the law says, as we know.
Right.
It's hard to represent a driver, especially even like a big rig truck driver, because they're a professional driver too. Why did they get caught up on the tracks? And half the time there's a very good reason for it. these train tracks are often unguarded. There are no lights and bells and all that stuff. By the way, if there are signals, typically that is federally funded, and you can't even sue over that crossing being set up properly if it has lights and gates, because there's essentially an immunity that the railroads have gotten by using federal money on these projects. The only exception to that is if the lights and gates themselves malfunction. If you have a signalization problem, which is kind of what you described, where it didn't operate as it's supposed to, then that can be a claim against the railroad. But the most common thing you'll see, and this is all across America in these private crossings, is not so much in town, but a little bit out of town, where it's a private landholder. Maybe it's the entrance to a new development or something in the rural parts that are becoming more suburban. And that train is ripping through there. If it's Amtrak, it's 70 miles, 75 miles an hour. If it's Norfolk Southern, they're going through at 50 miles an hour. And the driver may be coming off of a road where it's 55 miles an hour. He takes a right turn, and all of a sudden he's faced with the railroad tracks. Even if he knows there are tracks there, a lot of times the visibility is obstructed by buildings or trees, so the sight line isn't that good. And even where sometimes there'll be a stop sign and it's not put up in the right place. And now if you stop at the stop sign, you can't see. If you pull up all the way to the tracks and you get to the last 15 feet, now you're in the zone of safety where something on the train could hit your car. So it really is there are a lot of death traps out there. I think the word to fellow lawyers is, if you have these catastrophic injuries, it's certainly worth looking into. But there's a bunch of complicated questions about public crossing, private crossing, signalization or not. And then a lot of these cases hinge on visibility for the driver. Can they see far enough down the tracks to prevent getting caught up on them? And so those are some of the issues in these crossing accident cases. Lots of tragic results. And a lot of times we're saying, sorry, we really can't do much about it.
Yeah. And I'll be honest with you, I don't remember what happened on that case. I think I'm in North Carolina, so we had contrib, and I think it was like you could see, and it was night, so you could definitely see a light,
But there's so many things. Train whistle stuff it's almost silly, because you don't really necessarily hear the train whistle, even if they blow it properly, because the wind can affect it. All kinds of different things can affect it. And then what the train crews have been told to do is, as soon as they hit that car or truck, then they're definitely laying on the horn and blasting it. So everybody in the neighborhood says, oh yeah, I heard the horn. It might have been the after the crash horn.
Right. Good deal.
So,
well, this is interesting, John. So if somebody happens to get one of these cases and want to talk to you, how can they get up with you, my friend?
Yes, thank you so much. We'd happy to talk to anybody about anything, but especially these railroad industry cases. Our phone is 757-333-3333. We thank Ms. Cassidy, our great marketing director, for getting us that cool number. So 757 area code, then all threes. And, J. Cooper at cooperhurley.com as well. But we try to make ourselves easy to find. Give us a call anytime, and we're happy to go over it with you. No obligation, just try to point you in the right direction. So part of the reason we're thrilled to be here with you today is to share this with PILMA, share this with our brothers and sisters at law, so that they'll know this case when they see it and be able to get it.
Definitely. And I think it's just, like I said at the beginning, riches and niches. I mean, I think we need to always be thinking about these outlier cases, because, you make 80% of your money with 20% of your cases, the old 80-20 rule, right?
Yeah,
good deal.
Exactly.
Well, listen, I thank you, and hopefully I'll see Cassie. I don't know if I'll see you down at our summit in May, but if I don't, take care. And if I do, I'll shake your hand and buy you a soda.
Thank you so much, Ken. And we really, have been, as you know, with PILMA for a long, long time, and our firm has just done phenomenally well, and we really appreciate you and the organization.
Oh, well, thank you very much. I appreciate it. Well, you got good people, and and like I say, people that implement usually do pretty good with PILMA. They usually grow pretty amazingly. You got to take action.
Well, greetings from Jim Hurley and Cassidy, and hope to see you soon.
All right, take care. Until next time, this is Ken Hardison, dedicated to your success.
You have been listening to the Grow Your Law Firm podcast, the podcast that leads lawyers to more growth, profit, and freedom. Go to growyourlawfirm.com to find more ways to market and manage your law firm. Please leave us a rating and review wherever you listen to your podcasts.